we need to ban assault weapons and high-capacity magazines. And if we can't ban assault weapons, then we should raise the age to purchase them from 18 to 21. Strengthen background checks. Enact safe storage law and red flag laws. Repeal the immunity that protects gun manufacturers from liability. These are rational, common sense measures.
So Oregon Measure 114's firearms purchase permit and magazine ban trial is currently underway, and it will be determined whether or not the new measure is constitutional or not. So let's talk about this. But real quick before you jump in this video, if you think a magazine ban and a permit to purchase is clearly unconstitutional, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is MyBookie. This month, college and NFL football is once again back, and so your chances to win with MyBookie are now available. NFL and college football and a brand new cash out system gives you the option to bet and win on these NFL games and college games if you want to this season. MyBookie allows you to bet safely and securely on all games if you want to enhance that viewing experience. I know some people like fantasy football. I love fantasy football, and some people like to bet on games when they're watching them. And again, it just enhances your viewing experience if you would like. To get started, you can go to mybookie.ag and register for a free account. And when you're ready to make your first deposit, you can use the promo code SCHOLAR to get a 50% deposit bonus for free. Again, use promo code SCHOLAR to claim that free 50% deposit bonus, and make sure you bet responsibly. And thank you again to MyBookie for sponsoring this video. As I mentioned in the intro, in this video, we're going to be discussing some current challenges to Oregon Measure 114. This measure, which passed in the state of Oregon, creates a purchase permit that Oregon residents must obtain to be able to purchase firearms within the state, and also it creates a ban on so-called large capacity magazines. In response to this Measure 114, the state is now being sued in multiple cases. The cases we're going to be focusing on in this video specifically is going to be Arnold v. Kotek. That is the state case. The Arnold case is a challenge brought by GOA in state courts, and it challenges Oregon Measure 114 as a violation of the state of Oregon Constitution. There is also the OFF case, which is a federal lawsuit, which I'm going to mention real briefly because it's also important for what's going on within the state of Oregon. Now, the last time we talked about the Arnold case, I informed you guys that the judge in that case extended a TRO, which essentially barred the permit scheme from going into effect. And then he also granted a preliminary injunction, which barred the magazine ban from also being put into effect and being enforced within the state. This was a significant temporary win. However, in this case right now, there is a trial taking place this week. It is set to be resolved this week. And then the question is, what's going to happen going forward? Because although there is a TRO and a preliminary injunction in place, which is essentially preventing the measure from going into effect, once the judge issues his final determination, all of that will be irrelevant, and it will just be whether or not the judge found that Measure 114 is unconstitutional and he strikes it down entirely. Now, for those not familiar with what Oregon Measure 114 does, let me explain generally what is going on. Oregon Measure 114 first requires that anyone purchasing a firearm must obtain a permit to purchase. To obtain the permit to purchase, the resident will need to complete a safety training course, go through a background check, get fingerprinted, and then also show a valid ID. And then only after all that would they get a permit that is granted to them so that they can then purchase firearms. However, Measure 114 did not stop with just creating a permit to purchase. The second significant thing that it did is it created a ban on the future sale, purchase, transfer, and possession of any so-called large capacity magazine. Under the measure, there is a future ban on any magazine that holds more than 10 rounds, but those magazines that maybe you possessed before it went into effect, they're going to be grandfathered in, but it's a prospective ban. So the acquisition of any new so-called large capacity magazines would then be banned. Now, one of the major issues with Measure 114 was that there was no way that it would have been implemented by the original December 8th deadline. There was no way that the state was going to be able to put into effect. So it would have had a complete ban or halt on the purchase of not only magazines, but pretty much all firearms because the state was not ready to implement it. In response, multiple cases were filed to halt the measure from going into effect. There was the GOA state lawsuit, which is Arnold v. Kotek, and then there was the federal case, which is the OFF v. Kotek case. Arnold is a challenge to the measure using the state constitution, while the federal lawsuit is a challenge under federal law and then also the Second Amendment, and it's trying to use the current Bruen decision to also get this measure struck down. Originally, the federal court judge in the OFF case put a temporary halt on the permitting scheme from going into effect, at least for 30 days. but the magazine ban was going to go into effect under the federal lawsuit. Early on in the OFF lawsuit, all indications were that the federal court judge was not going to be very two-way friendly. However, in the Arnold state lawsuit, the Harney County District Court Judge Robert Roschio, did grant an outright TRO halting the permitting scheme from being put into effect, and then also halting the magazine ban. Then subsequent to that, there was a hearing on a motion for preliminary injunction. At the hearing, Judge Roschio upheld his order to temporarily restrain the permitting scheme from going into effect. Judge Roschio set his order to remain in effect until he received notice from the state that the new permitting scheme was up and running and could be enforced. Now, after that hearing, he also issued an order granting the preliminary injunction, which currently prevents the magazine ban from being enforced within the state of Oregon. So the state court extended the TRO and then also a preliminary injunction, which currently prevents Oregon from enforcing Measure 114 until the state case is finally decided. Now, while all that was going on, there was also that federal lawsuit, which is the OFF case. The judge in that case held an expedited hearing on the measure, and recently she ruled and then upheld the permitting scheme and then also the magazine ban. So she ruled in favor of Oregon Measure 114. She found that both laws are constitutional even under the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruen. In that ruling, she attempted to narrow the ruling of Bruen. She tried to say that Bruen recognized only conduct protected and recognized as a central component of the Second Amendment, like self-defense is indeed protected. She tried to say that only self-defense is recognized as something that's protected under the Second Amendment. In her ruling, she stated that hunting and other recreational uses of guns have no explicit or otherwise direct protection in the text of the Constitution or under existing doctrine, nor does the historical evidence support such a conclusion. So she tried to say that other conduct outside of self-defense is not protected. Then she went on to try to find that so-called large capacity magazines are not in common use for lawful purposes. She did this by changing the common use test, and she ruled that the intent of a gun owner to maybe have a magazine for something like self-defense does not matter when you are looking at common use. Instead, she believes it's actual use that makes something common. She stated that this court finds that sheer commonality is not dispositive in determining whether a particular firearm or firearm accessory is protected by the Second Amendment. As such, this court finds that an individual's subjective intent in purchasing a firearm or a firearm accessory for self-defense, while relevant, also cannot be dispositive in assessing whether a firearm or firearm accessory is in common use for self-defense. What this reflects right now is some of the legal battle that's going on right now in this case and other cases about what is common use. Some people are trying to say that common use is actual use instead of just common ownership. Now, despite that federal decision on the preliminary injunction, there was still the state court's TRO and then the state preliminary injunction that currently is preventing Measure 114 from going into effect. Well, now the state court trial is underway. It's happening this week, and there's a lot of questions about what's going to happen going forward. How is the state court going to rule after this hearing? This week, the court is hearing arguments from both sides, as well as hearing testimony from a variety of witnesses and experts in this case. Recently, the judge found that the testimony on the number of rounds that the police and sheriff in the state have and carry with them is in fact highly relevant, and it's highly relevant on the legality of Measure 114, and he's using it and he's going to take it into consideration in determining whether or not Measure 114 is constitutional or not. This is interesting because the state wanted that testimony to be excluded and they did not want the judge to consider that type of testimony. That's because that type of testimony shows how contradictory the measure is, since police officers and sheriffs commonly have on them magazines that hold more than 10 rounds, and it can't be that they're so dangerous and so unusual and so uncommon, and you would say that they need to be excluded from the average law-abiding person for self-defense, but then you have police officers and sheriffs commonly choosing and carrying with them magazines that hold more than 10 rounds. There are also reports that some of the state's testimony was in fact excluded as irrelevant. It seems like the judge is still very favorable and is very pro two-way, and the hope is that he will rule ultimately in this case in favor of the two-way side. Now, keep in mind, this is a challenge to the measure using the Oregon state constitution and some of the language that they have in their state constitution. So that's going to be how this is all framed and how it's decided. It's not going to be on the whole Second Amendment question. It's going to be more state specific. But for now, the magazine ban in the permit scheme is still halted. But after the hearing this week and after it finishes, the question is, how is the court going to rule? Are they going to strike down this measure altogether and find that it violates the Oregon state constitution and some of the Second Amendment language that they have in their state constitution? So that's what's currently happening in Oregon and with Measure 114. And if anything else develops, I will let you all know. So if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.